Hi everyone, I'm Sabrina.
And I'm Jonathan. We are the lawyers at Varity Law.
As an estate lawyer, I have been appointed as estate trustee, also called executor, for several probate files.
Yes, this means that Sabrina will be managing the estate for those clients. She would have many duties, like opening an estate account for the deceased, filing for and paying estate administration taxes, notifying creditors and paying off debts, hiring an accountant to file for the deceased's last year of income taxes, and finally distributing the estates to the beneficiaries.
Wow, yeah, I am very busy, all right.
And certainly. Well, I know the first step is gathering details about everything that the deceased owns. Many people assume this is an easy process. Is it?
No, unfortunately, the opposite is true. In Canada, there is really no central database that summarizes everything you own. Imagine that. A lawyer can just type your name in some database and then poof, a list of all your bank accounts, real estate, stocks, vehicles, and companies pop up.
Oh, I'm sure most people would disagree with this invasion of privacy. So, in reality, what happens?
Well, I must act as a detective. I must search for each type of asset separately. For example, for real estate, I need to access the land registry office and search for the deceased name city by city.
Oh, wow. You can't search for the deceased's real estate all at once?
Nope.
Well, what happens if there are people with identical names?
Then I must buy the title search and look up the owner's date of birth and other details. It's very time consuming.
For sure. What about bank accounts, though?
For that, it's even harder. At least for real estate, I am already authorized to access the ownership information, being a lawyer. But for bank accounts, I must go to each bank and talk to their estate department. I must submit a bunch of documents, including probate approval certificates, the death certificate, the deceased bank cards if those weren't lost. From then on, it still takes the bank anywhere from a few days to a few weeks to set up the estate account. Only after all that, I can finally access the deceased money.
Well, that is a lot of work. And you have to go to every single bank?
Well, the rule of thumb is that I go to every bank with which the deceased had a bank card or statement. Now, sometimes it's a total bust because the account could have been closed ages ago, but I still have to verify just in case there's any money. Better safe than sorry.
Definitely. Now, you must then centralize all the money into a single estate account, right?
That's correct. I cannot simply transfer the money to the beneficiary's account yet. Everything must first enter into the estate account.
Why is that?
Well, for two reasons. If there are uncashed checks or other payments to the deceased, then those can only be deposited into the estate account. So, for example, I cannot take a check where the payee is John Smith and deposit that into the beneficiary's account. Let's say her name is Linda Smith. Rather, I need to first save the check into the estate account, and then I write another check to Linda Smith from the estate account.
That makes sense. And the second reason is that debts and taxes must be paid out first, right?
Yes. Before beneficiaries get their money, I must pay out all debt, including funeral expenses, mortgages, vehicle loans, credit cards, etc. Then I must file and pay the 1.5% estate administration tax. Once the accountant does their terminal tax return, I also need to know if the estate needs to pay for any income tax. Only after all that can I distribute the rest to the beneficiaries.
Well, can't you give some of the money to the beneficiaries first, like if there's an urgent need?
I can, as long as I ensure there will be enough money left to pay out the debt and taxes. If there won't be enough money left, then I will be held personally liable.
Whoa, that's scary. And is this true for any executor or just professional executors like yourself?
It's true for all executors. So if you're appointed as executor, even if you're not a professional like a lawyer, you must ensure all debt and taxes will be paid out. Bookkeeping is essential. You must have clear receipts of all deposits into and withdrawals from the estate account. Otherwise, you can be held personally liable. Being an executor is definitely a serious role with grave consequences if any mistakes are made.
Now, speaking of debts, we previously talked about how creditors can charge interest or even sell an estate property if they're not being paid on time.
Well, that's correct. So the first thing I do, even before I get probate approval, is contacting all the creditors and letting them know what's going on. Fortunately, if the creditors receive a reasonable and trustworthy timeline on when they can be paid, they will usually not start power sale. For example, I can tell them the probate approval will likely take 6 months, And from then on, the property will be sold in 3 months. So you'll be fully paid in approximately 9 months.
But we have met some creditors who are not satisfied with these timelines, right?
Yes. So in those cases, ideally, the beneficiaries can pay for the estate debts themselves out of their own pockets, and then they can be fully reimbursed from the estate once probate is approved.
This is also why it's a great idea to leave your beneficiaries things like life insurance or a TFSA or RRSP with designated beneficiaries. Those funds, which are immediately accessible when you pass, can be used to pay out the estate debts first.
For sure. Then your beneficiaries can also take their time in selling the estate property instead of having to sell it in a rush.
Yes, as long as they are aware of the tax consequences first. In our previous videos, we stated that if the real estate property is the deceased's principal residence, then the beneficiaries can sell it in the deceased's name, tax-free. This is much better than first transferring the property into the beneficiary's name if the beneficiary already has a house, because selling a second property would result in capital gains.
Exactly. Now, in most cases, CRA will allow an estate property to count as principal residence for a whole year after the deceased passed away. Thereafter, it will be an uphill battle trying to convince CRA that the estate property is still a principal residence and not an investment property. I mean, the property owner has not been living there for over a year. How can it still be considered a principal residence?
Very true. So if we put things on a timeline, probate without a will takes, on average, a year for the court to approve. Luckily, this process can be shortened with an experienced and knowledgeable law firm who won't make mistakes that could require multiple back and forth to correct these documents.
Right, but to be safe, let's still stick with the 1 year processing time.
Okay, so you should be selling the estate property within 1 year after the deceased pass away, and the court takes around 1 year to assess the application. So you really should be applying for probate within about 30 days of the deceased's passing.
Of course, you can still apply later, but then problems like unpaid estate debts, tax deadlines, and legal claims from other relatives will become much bigger and more serious.
Very true. Now last but not least, fees. Sabrina, how much do you charge to act as an executor?
So I charge 5% of the entire estate, which is pretty much the market rate for lawyers to act as estate trustees.
Very true. So basically the same as an insurance bond. Since estate lawyers are audited every year they act as executors, courts are usually more relaxed about lawyers as executors and are far less likely to require a bond insurance policy. So between paying the 5% bond insurance and paying the lawyer the executive fees, I'm sure most people would choose to pay the legal fees.
Yeah, for sure. Then they don't need to do anything afterwards but wait to receive their inheritance. Also, I don't double down on legal fees. Now, if you choose a non-professional to be executor, they are entitled to charge the 5% of the estate service fees. On top of that, they can still hire a lawyer to help and pay their legal fees from the estate.
I see. So the estate is really paying double, legal fees and the 5% executive fees. But hiring you in our firm means that they only get the 5% fee and no additional legal fee is charged.
Exactly.
Well, thank you, Sabrina, for that very informative discussion about lawyers acting as executors.
No problem. Thank you everyone for tuning in. We will see you in our next month's video.